this morning on the matter of In Re AB. Justice Simonis, as you know, has retired. Justice Lee's retirement is pending. As a result, we're pleased to be joined by Judge Matthew Bates of our 3rd District Court and Judge Jennifer Brown of the 4th District. We very much appreciate their willingness to help us out on this matter. A few thoughts before we begin. If there's a technological glitch, don't worry, we'll take whatever time is necessary to give you a full opportunity to present your arguments. Probably helps in that regard if you mute yourself when not speaking. We have allotted the time as per usual, but it is our practice to continue to ask questions as long as we believe it will be helpful to our understanding of the case. So if you're still getting questions from the bench, you may continue to respond, and you need not ask permission to do so. Any such time will not count against any reserved time. Now that may mean that at the end of the day, one side has had more time than the other. That's simply a function of how many questions we had of your case. If we have a question, we will raise our hands to get in line. That's to signal to each other and to you that we do have a question, and we'd like you to get to it as soon as you reasonably can. You don't need to stop mid-sentence, but as soon as you reasonably can, we'd appreciate your getting to our question. Okay, I think I've covered all the preliminaries, so let's hear counsel's appearances.
Martha Pierce, attorney guardian ad litem for the minor child.
Good morning, Ms. Pierce. Good to have you with us.
Shelley Harding, appearing for the great aunt and great uncle, who are appellants in this case.
Welcome, Ms. Harding. Glad to have you join us as well. I'm sorry, Mr. Christensen, you're muted.
Bound to happen. Thank you, Your Honor. Steve Christensen appearing for the mother, who is Krista Thompson.
Welcome, Mr. Christensen. Okay, let's jump into things.
May it please the court, Martha Pierce, attorney guardian ad litem for the minor child. I welcome this opportunity to speak to the court, and I welcome your questions. I particularly welcome that 2 of our members of the panel today are drawn from the trial court bench, because we're going to be discussing standard of review. And standard of review has to do with how much we respect the work of the men and women who sit through days and days of trials that are sometimes tedious and sometimes dramatic, and who make numerous determinations going to weight, credibility, demeanor, inference, and so forth. This court has asked me to address 3 questions. The first one is whether or not the Court of Appeals correctly applied this court's case law in In Re ER, and I suggest that it did not. In Re ER dealt with the issue of best interest, but it affirmed In Re BR, which dealt with the issue of neglect. In Re BR applied a clearly erroneous standard of review to the issue of neglect. And indeed, that standard of review goes back as far as 1912. The first 60 years of Utah's child welfare law have fact situations very similar to the present one, where a parent has to rely on family members, the community, the child welfare, the Children's Aid Society. They drop the child off and then they come to pick the child up. That was a very common scenario. And often the guardians weren't so happy to return the child. And in each case, the Court of Appeals, the Supreme Court said, we're going to give great deference to the trier of fact because the underlying facts are so various and so complex, and we need to really respect what the trial court did. The fact that, and I think it's specious to say that because for purposes of this argument, mother was not challenging the findings of fact, I think that should not give the Court of Appeals leave not to consult the record, because the record informs how we interpret those facts. And it's very clear in the Court of Appeals opinion that interpretation of the findings was going on. For instance, how the Court of Appeals saw child's suicidal ideation. They brushed it off as, well, this is just typical of adolescence. But the record and the juvenile court determined that this was a very fragile, traumatized child who really did have suicidal ideation and needed specialized care. Yes.
Ms. Pierce, did the lower court, in your view, find that that suicidal ideation was caused by mother's actions or inactions?
Yes, and it's reflected even in the Court of Appeals in paragraph 7 of their opinion. They discussed that mother's parenting method rendered harmed the child. So I
yes,
think,
go back to the lower court though. What finding can you point to on causation?
well, paragraph 7 of the Court of Appeals is actually quoting the lower court.
Okay.
So I think that answers that question, that she found that that was the case. And then I think, and if you recall the pocket dial happened when we heard the mother's abusive comments to the child. And aunt and uncle said after that, they saw that the child was just not herself, that she was traumatized, that it took a while to get her back. She was truly frightened, and she had reason to be frightened. So you even had that extra bit of evidence where the court actually heard mother's abusive conduct, and then her testimony.
That was in the presence of the child?
Yes, the pocket dial, aunt and uncle were listening to mother yelling at the child, telling the child that she needed to tell her guardian ad litem that she wanted to go home. She needed to tell aunt and uncle that she wanted to go home. And if she did not, quote, a lot of people are going to get hurt. And it was very frightening. And mother never intended for aunt and uncle to hear that. It was a pocket dial. But that it was very crucial information about this is really how mother behaves around the child. And
I guess it was the evil comment that was outside the hearing of the child, or am I wrong on that?
The mother, well, to her face, the mother would use that kind of language to the child.
Well, yeah, not that. I didn't see anything about evil.
And I can't recall.
But she certainly said other things.
She did say other things, and I couldn't really pull out what she said behind her back and what she said to her face. But this is a mother who was, very emotionally abusive to this child. And then the mother herself presented testimony that the child would cry all day, that the child said she wanted to kill herself. So we do have that evidence of how fragile this child really was. And that brings us to this. If you're done with ER, then I can go on to the second question. And my colleague will answer it in more detail. But I think the findings are ample to support the ground of neglect. And again, I think in fairness to the trier of fact, you can't look at the findings without using that great body of evidence to inform the meaning of those findings. You need to do that. It was the judge took 3 days of evidence, and we need to respect what the judge did. And I think a big mistake that people make is looking at child welfare law through the lens of criminal law. Abuse, neglect, and dependency are not criminal elements. There's no mens rea. There's no elements that someone on a certain day at a certain time did a certain thing. Abuse, neglect, and dependency describe the status of a child. This is a status adjudication. And it doesn't matter how many counts of neglect you get or how many counts of abuse or dependency. Whatever the juvenile court finds, it has to, is the disposition. It consults 83-405 and 80-3-406. And abuse, neglect, and dependency opens the door for the juvenile court to use any of those dispositional options available to it.
Ms.
So,
Pierce,
yes.
can I ask you about the legal standards for abuse, dependency, and neglect. So one thing I thought that's interesting, if we look specifically at the language of the statute, is that it's not as explicit in terms of what the juvenile court needs to find as you might expect. So you have in 81-102, you have definitions of abuse, neglect, and dependency. There's also a definition of adjudication, which the definition in 102.3a is finding that the facts alleged in the petition have been proved. So that's the definition of adjudication. And the only direction I could find to the juvenile court is that, so in 83-1021, it says, abuse, neglect, or dependency petition means a petition alleging that a child is abused, neglected, or dependent. Okay, so that's what it's supposed to allege, and it's supposed to plead facts along those lines. Then in 83-4021, this is the only direction I found to the district court in this chapter 3. If at the adjudication hearing, the juvenile court finds by clear and convincing evidence that the allegations in the petition are true, then the juvenile court shall conduct a disposition hearing. I would expect to see something about if the court concludes that it meets the definitions of abuse, neglect, and dependency. But both in the definition of adjudication and then in this instruction in 4021, it just tells the juvenile court to find if the allegations in the petition are true. And I guess we can assume that in there, the court is supposed to find that those allegations, if true, meet the definitions of here neglect. But I thought it was unusual that the statute doesn't more explicitly say that. I kind of assume it or imply it. Am I missing something? Is there another area that covers this? Or
no,
frankly, as an expert in this area, what am I missing?
Well, until you mentioned that, I never saw that wasn't there, because like you, I always assumed that what they really meant was if the juvenile court made that, oh, here's what okay, now I can think of a statutory basis. If you look at under the juvenile code, under the jurisdiction of the juvenile court, it says a juvenile court has jurisdiction over children who are abused, neglected, and dependent. So there can be a case if you find the allegations true, but it doesn't amount to abuse, neglect, or dependency, that child would not fall within the jurisdiction of the juvenile court. And this court found as much in NRA KT, where the parties stipulated to a very thin set of facts. So there was no underlying record. And that thin set of facts did not amount to abuse, neglect, or dependency. So even though the petition was true, it didn't rise to that level. Yes, Judge Brown?
The juvenile court wouldn't have jurisdiction because they don't unless they adjudicate the child.
Yeah, exactly.
Because neglected, abused, or dependent.
Because that's the basis of jurisdiction, the child's status. If the child doesn't attain that status, there's no jurisdiction. Okay,
that helps. Can I ask one more question along these lines? So it seems like some of the legal standard of neglect that you're using is more in the parental termination context than in 80-3. And so I'm wondering if that matters. Does that, and I don't know if that's dispositive of the case, but or if this matters one way or the other, but should we just be looking at the definition of neglect? Or can some of the other definitions from parental terminations carry over and inform the analysis?
Well, one would think, well, first of all, the termination code consults the adjudication code for the definitions of neglect. And second of all, one would think that if the criteria that meet termination, that it would likewise meet the lesser remedy of status adjudication.
Okay. Thank you.
Yes.
And I know our time is short, but I'd like to go back just a little bit to the deference issue because I struggled with this as I read through the briefs. Is it your position that the deference that is entitled to the district court basically required the Court of Appeals to remand versus accept the findings as true and make the application to the definition of neglect in the statute as the Court of Appeals did? I mean, are you arguing for a deference that basically requires remand versus what the Court of Appeals did to say we're taking those findings of fact as true and applying them to the definition under the statute and just making a determination that the trial court didn't make the connection that it needed to in the record?
Well, that's partly deference, but it's also partly just the rule of law and how an appellate court conducts its business. That the remedy for inadequate findings is to remand. The remedy for, and in fact, this court just recently in NRA JAL 2022 Utah 12 found this was a mixed question review, but they found there was an embedded question of law that the juvenile court got wrong. But instead of saying we're going to dismiss the termination petition and everybody go home, this court said no, we're going to remand for rehearing to the juvenile court to get it right, because the juvenile court deserves a chance to get it right, and we're not going to put a child in danger. We're going to send it back to get it right. Justice Durant?
I want to take you back to my first question. I've pulled up footnote 3 in the Court of Appeals opinion. That's the one you were referencing,
Right.
correct? It refers to the trial court having found maltreatment, and addresses whether that qualifies in whether the court intended emotional abuse. Refers to the fact that she's thriving. My question went to causation. Did the juvenile court find? We have the findings regarding maltreatment, no doubt. We have findings about improper parental conduct. Do we have a finding that the improper parental conduct caused the suicidal ideation or the other emotional fragility?
Well, again, I would say that paragraph 7 of the opinion, which in turn quotes one of the findings of the juvenile court, makes that connection.
Which finding? You're talking about paragraph 7 of
the
Court
opinion.
Of Appeals opinion?
Okay.
I'm
Annabelle
reading.
has been neglected by mother in the form of emotional maltreatment, which has caused Annabelle to be insecure, afraid, and emotionally disturbed. So
Thank you.
There's the causation. And then paragraph 7 goes on to recite other findings of fact from the juvenile court that I think gives you that causation.
Thank you.
And again, I think it's all there. And in most cases, by the time you get to court, the child is in substitute care and the child is thriving. And the 60 years of case law I mentioned, the child has been in substitute care and is doing great, but you still can look at whether or not the parent fulfilled their parental duties. We don't have to make children suffer. That is why one of the definitions, in the definition of abuse and neglect, they also include threat of harm, because we don't want to wait for a child to suffer before we take jurisdiction. So we also look at threat of harm, and the pocket dial certainly was a threat of harm. If there's no other questions,
Under the abuse statute,
exactly.
You'd need to show harm from the threat of harm, correct?
You need to show threat of harm, not necessarily harm.
So I'm talking about the abuse section.
Right.
You don't think harm need be shown to establish emotional abuse?
I think no, because emotional abuse pretty much says that you've got harm. I agree. But abuse is broad enough to include harm as well as threat of harm. And neglect, you don't have to show harm. And indeed, there's a case in Ray CB where there was no harm to the child. the boyfriend had shaken the child, put the child back in the bed. Mother checked on the child was unresponsive, and mother didn't seek medical help for the child. It turned out that medical help would have made no difference at all. The child essentially was brain dead. And so mother said, look, you can't say that I medically neglected this child because it didn't make a difference. And the Court of Appeals, using a reasonable parent standard, said a reasonable parent would have sought medical help. And so you can't say that so this did make out a case for neglect, even though there was no causation on the part of the mother.
So one of mother's arguments is that if we construe this court's finding as emotional maltreatment as satisfying the emotional abuse section, as opposed to the negligence section, that essentially undermines the requirements of the emotional abuse section. And I think what you're indicating is one of the distinctions between the neglect section and the emotional abuse section is that under the neglect section, harm need not be shown, but under the emotional abuse section, harm must be shown. And you point to a finding that there is harm regardless.
Exactly.
Yeah. Do you have any other response to the argument that basically here the court explicitly rested its finding on the neglect section as opposed to the emotional abuse section, and that to nevertheless find emotional abuse undermines the requirements of the emotional abuse section? Or can you speak to any other differences in these two sections?
Well, as I argued in my brief, there's going to be a lot of overlap between abuse, neglect, and dependency. There just is. And oftentimes the juvenile court, their findings don't even distinguish that. They just conclude the child has been abused or neglected or dependent. They just leave it at that. And that pretty much has been the history from the beginning. You just play it all. And there's going to be overlap, and that's okay. This isn't a criminal case. This is a status adjudication. So any of those three statuses will get you in there. We wouldn't even be in this place if the juvenile court had found dependency. And again, I think if the findings have to be informed by the record, and the record, they're constantly referring to emotional abuse of this child. And what we know about emotional, go ahead.
Now, do the findings need to track or even relate to the statutory neglect factors?
I think this court in NRA JAL said that they do. And NRA JAL said that when they do not, then the remedy is to remand for rehearing. But I think the court found that the mother did not fulfill her parental duties, that there was a lack of parental care, and that gets you neglect. I think there's plenty of care. I think you get neglect under abandonment, you get neglect under failure to provide, you get neglect under failure to refuse or to provide.
Thank you.
If there are no other questions, then I'll turn it over to my colleague. Thank you for your attention.
And Ms. Harding, you do have your full time, 10 minutes.
Okay. Justice Duran, I just wanted to point out that what you were looking for is in the original opinion on page 6. It's the second conclusion of law, and it says Aliana has been neglected by her mother in the form of emotional maltreatment, which has caused her to be insecure, afraid, and emotionally disturbed. I think that's what you were looking for. I wanted to run through the facts.
I guess it was the suicidal ideation. You can infer from that finding that it went to the suicidal ideation, which seems to me to be the most serious harm. I'm not sure insecurity would get you to the kind of permanent or long-lasting harm requirement under the abuse section.
Correct. And I think it's the emotionally disturbed, which is tied to the suicidality. So I wanted to quickly go through some of the facts in the opinion of the juvenile court. Court found that the mother's parenting style lacks affection and nurturing, and in juvenile court, that's really significant. Lack of hugging and very little affection is neglect. There was no financial assistance for raising her child, and she was unemployed. There was emotional maltreatment. There were fights involving domestic violence, which was throwing a table in the presence of the child. There was name calling, jackass, bitch, dumb, stupid, leave me alone, bitch, why are you acting like a bitch? And I can tell you that when those quotes came out in our trial, our judge was deeply shocked. The mother had physical and emotional ailments that interfered with parenting. That's dependency, of course. The child was suicidal with a lot of rage and hatred for her mother and was completely depressed. Mother admitted that she wanted to sell her child on the black market earlier in child's life, and that sheds light on bonding, the court concluded. That's neglect. Child was depressed and sad after visits. That shows harm. The mother had a threatening conversation with the child about telling the guardian ad litem that she needed to tell the guardian ad litem she wants to go home or a lot of people will get hurt. And the court called that emotionally abusive in paragraph 16. Court found that the mother puts her own interests first and unloaded the care of the child on relatives and turned down additional opportunities to spend time with the child, and that's neglect. And again, finally, we have a child who's insecure, afraid, and emotionally disturbed, and that's the harm requirement. It's our position today that these facts all add up to neglect under 80-1-102, 51A2, lack of proper parental care by reason of the faults or habits of the parent. This is a huge category of neglect that the juvenile court uses a whole lot. The problem that we have is KY versus DCFS. This is a decision that I think is largely strong and solid, except the court used a dictionary to define emotional maltreatment to conclude that it can only be active abuse. And therefore, emotional maltreatment can only fit in the abuse category. However, this standard, sorry.
Can I just ask you a question about that? So KY has been out there for 12 years, and that's the Court of Appeals saying this is what we think the legislature intended with its definition. What do we do with the fact that, well, let me not assume that. It appears to me that in the past 12 years, the legislature hasn't done anything to address the definition the Court of Appeals, or the gloss the Court of Appeals put on the definition of neglecting KY. Is that your understanding too?
Yes.
So what do we make of the fact that the legislature hasn't swept in to modify the statute in response to KY? It might not be strong evidence that the Court of Appeals got it right with respect to legislative intent, but it seems like it's some evidence that the legislature is okay with the way the Court of Appeals has defined it. And what do we do with that?
Well, it could take some lobbying to change law, and I think there hasn't been a focus there. But also, if you look at neglect as it's defined under sub 51, it says neglect is action or inaction. So it seems to be covered by the legislature. They say neglect is either. It's the Court of Appeals that has decided it is something different. And what I think is significant is that if you look at the psychologists out in the field, they say that psychological maltreatment encompasses both emotional abuse and emotional neglect. It is well settled in the field that both exist. And juvenile court practitioners and judges are trained by psychologists, and we all know they both exist.
And maybe that is the answer to the question, because I'm not sure that when KY was decided, neglect included both action and inaction. So maybe the legislative response was to tinker with that definition, if I'm remembering the timeline correctly.
And I'd have to check into that. I'm not certain. But I just also point out that domestic violence related child abuse is neglect. That's well settled and under case law. And it fits into that catch-all of lack of proper parental care. And domestic violence related child abuse.
Can I ask you a little bit about this, just kind of following up on this, because I'm trying to understand that if you have one category that is neglect and one category that is abuse, so you're trying to, the juvenile court's trying to determine, is this child neglected or abused? It makes sense that maltreatment that is neglectful could fall into the neglect bucket. So the findings about the mother not bonding with the child, withholding emotional affection, those type of findings seem to fit naturally in the neglect bucket. But the ones about the name calling and maybe the selling on the black market, that seems certainly, not having a normal parental love for a child or feeling that bonding to a child. Emotional neglect. But the ones that are more abusive, the name calling, I'm trying to figure out how those seem to more naturally go into the abuse category to determine if this is also an abused child. Do they weigh in both categories? And I'm talking about the maltreatment that is more affirmatively abusive and not just neglectful in that it's withholding, parental affection and love from your child and a lack of bonding with your child. Do they fall into both categories? Does
No,
that
they are.
make it get a little messy? What is your response to that?
No, I think you've got it exactly right. That when you are yelling things at a child, like you're stupid, you're a jackass, leave me alone, bitch, that's emotionally abusive. And our court found that it was emotionally abusive. And then the lack of nurturing and hugging, that is neglect. Our problem, though, is KY versus DCFS because it says anything emotional has to be abuse. Emotional maltreatment, it's all abuse. And what we're saying is, no, that's wrong. Psychologists don't look at it that way. Juvenile court practitioners don't look at it that way. And if you just look at domestic violence related child abuse, that's considered neglect. But what is it really? It's parents yelling and screaming and hurting each other in front of a child, and that emotionally impacts that child. It's frightening to that child. It's terrorizing. That's emotional, and that's in neglect already. So we would just like that definition in KY to be changed to recognize the reality that there's emotional abuse and there's emotional neglect. And in our case, we had both. Yes. Judge Bates. Sorry, you're on mute.
Muted, Judge Bates.
Let's try that. Can you hear me now?
Yes.
If proper parental care is loving and nurturing and supportive, and name calling and insulting is not proper parental care, wouldn't that name calling then properly fit under that definition of neglect, that is lack of proper parental care? If neglect is action or inaction, action that is the opposite of proper parental care, couldn't that be considered neglect?
Well, I think that's what our judge did consider it to be. It was lack of proper parental care. But there was room to say it was abusive as well, in that it was something that was actively occurring that was emotionally harmful. But I think it is hard to decide exactly where something fits. And I think the judge looked at that. At our trial, she said, I think this is bordering on emotional abuse, but she felt she had abundant evidence of lack of parental care. And so she put it in the neglect category.
So maybe if this was one thing I was wondering when I was looking at the statute for guidance about what elements almost did the juvenile court need to find as a legal matter. Do you have to determine there's enough evidence in the abuse category that this is an abused child, or enough evidence in the neglect category that this is a neglected child? Did the judge think there was some evidence of abuse, but not necessarily enough to adjudicate the child an abused child? So the judge considered that under the more general neglect category of failing to provide parental care? Or did the judge, because there was just enough with neglect, the judge decided to base her decision on neglect and didn't necessarily reach abuse or rule out abuse? Maybe it's not clear from the order.
Well, from the order in paragraph 16, that conversation, the pocket dial where a lot of people were going to get hurt, that's what mom threatened the child with. The court actually called that emotionally abusive. That's paragraph 16. I think at times courts will shy away from the abuse category because it does require the additional very significant harm component, and it's easier to get there through neglect. And another thing that happens in juvenile court very frequently is something that we sort of think of as um, sort of throwing a bone to the other side, basically saying, you know, I'm not going to find abuse today. I'm still ruling for petitioners, but I'm going to find neglect instead of abuse so that you can walk away from this proceeding not feeling like we've decided you're an abusive parent. So that often happens as well. But I just would note that throughout the trial, the court and all the parties were talking about emotional abuse. Emotional abuse made its way into the opinion, and there is proof of harm. So I think we can get at it either way, through abuse or neglect. Yes, Justice Durant.
Counsel, you and Ms. Pierce have pointed to some extreme incidents of improper parenting, certainly. My question is, what do we do with the proper parental care provision? And just speaking hypothetically, not this case, because we have to think about how our opinions, of course, will be interpreted. It's no doubt the case that every parent at times engages in improper parental care. So what parameters should we assign to the term proper parental care? At what point does it become sufficient to qualify as neglect?
You know, I think it's very difficult to quantify that because every fact pattern that comes into juvenile court is very different. And so that's why the juvenile court judges have the training and experience and discretion to determine when it has stepped over the line. And in this case, you know, the child was suicidal, was depressed, and was angry and raging and pretty miserable. And this was a chronic situation that had gone on for a very long time. So that added up. But I don't think you could come up with a bright line for every case.
Yeah, lots of parents who are great parents have depressed or sad teenagers, right? That's not to minimize the harm here. And lots of parents are less than nurturing and maybe don't hug as much as they should. Now, here we have the thing that stands out most powerfully here is the name calling.
Mm-hmm.
But and maybe you're right. Maybe it's hard to quantify, but we still may need to try to assign some additional structure or meaning to what kind of improper parental care rises to the level of neglect under the statute.
Mm-hmm. And I think that the studies that I attached are helpful. So they talk about the type of psychologically abusive contact a parent can have with a child. And as you pointed out, the name calling is really a big deal. When you're calling people, you know, dumb and stupid and leave me alone, bitch, that really harms a child. And I think there's a lot of information in that in the studies I've attached.
Thank you.
Okay, I think I've concluded.
Thank you, Mr. Christensen.
Thank you, Your Honors. May it please the court, the legal framework that this case comes before the court in is a determination of whether the juvenile court properly had or asserted jurisdiction. As already discussed, Title 78A6-103 2A establishes whether or not the juvenile court had jurisdiction. And in order to have jurisdiction, the court would have to determine that the child is a neglected child, an abused child, or a dependent child. Because the court is talking about a jurisdictional determination, this court should, and the Court of Appeals did, review this as a question of law. Yes, Justice Durant.
No, I don't have anything. Go ahead.
Sorry, I thought you were raising your finger. An interpretation of the question of law here is whether the court properly applied the neglect statute. The court was invited in the petition below to find abuse. Both the guardian ad litem's office and opposing counsel for the aunt and uncle argued that the court should find abuse, and the court determined that the facts of this case come under neglect. Our argument is that the court improperly applied the statute that defines neglect. In rate KY, the court specifically determined that emotional maltreatment is a form of abuse. It is not, does not fall under neglect. And the first paragraph of counsel's argument on appeal for aunt and uncle was to concede that emotional maltreatment is not neglect.
Mr. Christensen, what about the findings of emotional maltreatment that are more like emotional neglect than affirmative abuse, where the findings that the mother seems to not really care for the child in a parental way, that there's not bonding affection, there's not parental child bonding affection or love being shown to the child?
Well, there are findings that she does not show affection. I don't know that that's unique to this mother, or that is under the category of neglect. Neglect is very specific in its language, the lack of proper parental care. The statute doesn't go on to say the lack of proper parental feeling. I think it's focused on action. Yes, Justice.
Oh, please finish. And Justice Peterson may have a follow-up, but I'm just getting along.
Keep that in mind. I think the statute is specifically designed to address a certain definition, and that definition is limited to care. Did the mother provide the care the child needs, and that which is proper for a parent to provide? When you get into the question of whether there's emotional abuse or emotional maltreatment, that has been defined by KY to be under the category of abuse. And in fact, the statute invites that interpretation, because under the definition of harm, the statute goes into what exactly is the scale for determining when emotional maltreatment becomes, or emotional abuse becomes, something that would fit into the category of abuse, or that would give the juvenile court jurisdiction. All right.
Okay, let's stay with the failure to properly parent. Why doesn't that get the aunt and uncle where they need to be? And certainly, it's improper to, call your child names. Everyone would agree with that. And improper to suggest maybe a threat as to people being harmed. Why doesn't that get them there?
Well, I think the basic underlying framework of this whole question is a constitutional right. We have a liberty interest that is being protected here, as referred to by the Court of Appeals from the Hutchison decision. This, even though the Hutchison decision was dealing with a termination issue, I mean, we are also talking about severe restrictions on parental rights here, and the parents' parental rights are constitutionally protected. Therefore, the legislature has set up a rubric where there are strict definitions before the court or before the legislature has created a state interest that would intrude into that protection.
So what is the definition of improper parental care?
I would propose that improper parental care deals with how the parent provides for the child. I mean, we're talking about two different things. One is the care of the child, and one is the treatment or the feeling that the parent exerts.
There's another provision, though, that goes to subsistence and meeting financial needs.
That's true.
So what is the parental care requirement speaking to?
So, I mean, in terms of the subsistence, the medical care, the child's health, safety, morals, and well-being, that is dealt with in subcategory 3I. I think the proper parental care is the next, all of the other things that deal with not just the protection, but also the making sure that the child is doing well and cared well in a safe, nurturing environment. But I think the legislature is very deliberate in choosing the word care, not just, I mean, every parent has, I suppose, a different ability to show affection or to demonstrate their own personal connection to the child. But if the child has what the child needs so that the child is able to thrive, then I think that there is proper care.
So you referenced the Constitution. Are you suggesting that parental care is cabined by the parent's constitutional rights as a parent?
Yes.
So at some point, the care becomes so improper that it overrides any constitutional interest the parent has in parenting the child, but that we need to be cautious. And I don't want to put words into your mouth, but I'm looking for some way to properly interpret that first subsection.
Yes, I think that's right. But I don't think it's correct to say that a parent that is abusive or emotionally abusive now somehow bleeds into the neglect standard, because the legislature has painstakingly created a definition of harm that includes the emotional abuse component. And I think that go ahead, Your Honor.
I mean, the abuse section does seem, it does impose more rigorous requirements. Yes. And so I can see why we'd say if a judge finds neglect, doesn't necessarily get you to emotional abuse. But if you get to emotional abuse, neglect seems to require less. Doesn't that get you to improper parental care under the neglect statute? If you could satisfy the emotional abuse section.
Well, if you can satisfy the emotional abuse section, I don't think you need the neglect section, because then you would have abuse. But it's very rigorous. I mean, as you said in one of your questions, every parent has weak moments, moments when they might even yell or swear at a child, but that doesn't make that parent abusive under the statute. The statute requires a serious impairment. And in this case, there was no psychological testimony, there was no expert testimony, there was no finding made that the child was impaired in a serious way or in a lasting way. In fact, the Court of Appeals points to the fact that when the child got to the aunt and uncle, the child was thriving, well and happy. So it didn't seem like there was any lasting impairment in this case.
Why didn't, not lasting, but why wouldn't suicidal ideation, where there's a causation finding, get you to serious impairment? Go ahead.
Well, I don't think the causation finding is connected to the suicidal ideation. All the court found is that there was emotional maltreatment, which caused the child to be insecure, afraid, and emotionally disturbed. But the court did not say that the mother caused the child to have suicidal ideations. In fact, the court doesn't even elaborate on that specific finding. It doesn't say it was repeated. It doesn't say what it arose out of. It doesn't say that there was any plan or action. I mean, essentially, all we have is this one reference to an ideation. But I don't think we can read into the court's findings that somehow was caused by the mother.
Thank you. Judge Brown has a question.
Yes.
Actually, I took my hand back down because I think we've gone a little too far down the path, and I'm okay with not addressing my question. So thank you.
Okay. Very good. So,
Mr. Christensen, on the line of questioning that Justice Durant was engaging in with you, I wonder if, in a way, the findings that when the child arrived at the great aunt and great uncle's house, she was emotionally disturbed, and then after a period of a year with them was happy and thriving. That seems relevant to the cause of the child's being emotionally disturbed. That seems to sort of cut against your client. Can you respond to that?
well, I think what we're really talking about here is parental care, and I disagree that it cuts against her in the sense of how she addressed the situation. It certainly does seem to highlight that there was disturbance, and I think you're asking, can't we say that disturbance in the home is isn't that enough to arise to say the court is justified in connecting it to neglect? But I think every home has disturbance, and mom and daughter are yelling at each other, and that happens. It's not ideal. It's not what we hope for. And daughter went to aunt and uncle, and things cooled down. So, I mean, to the extent that it was helpful for the child, I think that was a strong parental decision. Essentially, we have extended family here that is sitting back there as a safety net. And we're not arguing that aunt and uncle were an improper choice. In fact, they invited this situation. They wanted to help. And I think that really should cut in favor of mother. Mother's not, not harboring the child, keeping her away from other contacts. She's recognizing her limits, and she's solving those. And so to get back to Justice Durant's question, I think parental care involves putting in place other things besides the parent. Is the parent willing to seek counseling? Is the parent willing to have the child engage in counseling?
Mr. Christensen, I apologize. I am going to break in on that because I don't want to go too far down the path on this one before I can ask my question.
Sure.
The court also made a finding about mother basically having no regard for the child's needs or placing her own interests above the child. And so you're making an argument here that her involvement of aunt and uncle was a good parenting decision, but we also have a finding that she was threatening when taking the child, that she was going to cut off all contact that this aunt and uncle had with the minor child. So wouldn't that be, again, a support of the juvenile court's finding with regard to that issue, that the mother seemed to have little regard for the child's interests in comparison to her own?
Well, there are several points in the findings that show a lack of the best parenting. I understand that. I think we have to acknowledge that that mother is not ideal at all times, but I think a finding that she said that if, this case was over, she would not have the child go back to the aunt and uncle that cannot be used to show what the actual findings are in terms of her treatment of the child back before the child was taken. I think, that's kind of a loaded question of, what has this litigation done to you? And do you feel like aunt and uncle have let you see the child? And, there are lots of speculative type assertions in that particular finding, but none of them arise to neglect. And that's what the court is
Sorry, I just want to make sure I'm clear on the timing though. Her arriving to take the child and this pocket dial or the threat, if I'm remembering correctly, that the aunt and uncle would not be able to see the child again, that came prior to the juvenile court's adjudication, correct?
No, I think that happened. Well, the pocket dial was definitely in the facts. The pocket dial was a fact that occurred during the case. So mother was essentially on supervised visitation, and on one of those supervised visits, the pocket dial is what happened.
But it was still before the juvenile court made its ultimate decision with regard to neglect. And so,
yes.
So are you saying it would be inappropriate for the court to consider that because it happened basically after mother tried to retrieve the child?
No, I mean, in terms of the chronology, mother came to retrieve the child first, then the court case started, and then deep into the court case, there was supervision and a pocket dial incident. Then there was a trial, and at the end of the trial, mother was asked the question, if you get the child back, meaning after this trial, not back at some prior time, but if you get the child back after this trial, would you allow contact with the aunt and uncle? And I think that's when she said that she would not allow contact with the aunt and uncle. So what I'm saying is I'm separating the pocket dial from the answer to that specific question, because that deals with how she would act in the future. Yes, Judge Peters.
Mr. Christensen, if we were to agree with the Court of Appeals that the juvenile court did not tie its findings and conclusions sufficiently to the definition of neglect, so if we agreed with them, why should we just reverse this outright rather than remand to allow the juvenile court to make more findings and conclusions if necessary? Why is reversal the right remedy?
Well, reversal is the right remedy because the court duly considered the facts underlying its decision. In fact, it had the findings rewritten a second time based on a motion that we filed. And essentially, the facts before the court are fixed. I mean, there are essentially all of the things that were testified to are now part of the record. I think they're unchallenged at this point. I mean, essentially, we've filed an appeal accepting the findings of the court. I mean, typically when you're remanding a case, you are remanding so that more additional findings can be made to because they're insufficient, but no one has argued that the court, no one's challenged the court's findings in that respect. I think the Court of Appeals has gone through the analysis very carefully to consider each fact and decide whether that meets the statutory definition. So I would say the answer is because the court has gleaned from the evidence all of the facts that were there to be put down. All right. Your Honors, I would just ask the court to determine that the neglect statute in terms of proper care is really referring to mother's outward actions to parent, and consider that her actions to parent were not neglectful, and that the assertions that she was somehow deficient are more maltreatment, and that there was no causation testimony or expert testimony to establish a serious impairment as required by the statute. Thank you.
You, Mr. Christensen. Ms. Pierce, so you're up next, right?
Yes, thank you very much.
Could I start you with a question? I want to follow up on Justice Peterson's question. Can you point me to a case or cases where we have remanded, even where the facts are unchallenged, the factual findings are unchallenged, where we have remanded to give a judge another crack at correlating his or her findings to a statute?
I can't, but that's all the more reason to give it back to the judge, because if you're going to reverse based only on the four corners of the findings without looking at the record, that's an egregious affront to the trier of fact. You can't do that. And this court may have all kinds of insights that weren't given to the juvenile court when the juvenile court redid the findings. And in terms of your question about proper parental care, let me suggest this, because you wanted to give some guidance. I think the focus is on the word proper, which linguistically is associated with appropriate. So it's care appropriate to that specific child. I think we'll all agree that it takes a very different skill set to parent, let's say, a medically fragile newborn or a robust 8-year-old, or in this case, a emotionally fragile child. So, and it also says necessary for their well-being. So you don't even know what proper parental care is unless you begin with the child. You have to do that, because some children are so labor intensive to parent, and some other children are resilient and easy, and they don't take a lot of skills at all. And many of the cases we have in our juvenile court involve high need children and low functioning parents. And through no fault of the parents, they just can't give the child proper parental care necessary for their well-being. So if this court were to give guidance, I would hope the court would focus on the word proper and would begin with the child. Yes.
Thank you, Ms. Pierce. If we were to review the record or send it back down to the Court of Appeals and ask them to review the record, your argument is that that would inform the factual findings and, I guess, indicate correlation with the statutory factors. Is that your position?
Well, my argument is that this court's first choice, I think, would be to presume the regularity of the proceedings and allow the record to inform the findings and to affirm without having to remand. The second choice would be to give the trial court a chance to get it right with guidance such as begin with the needs of the child under proper parental care, and to allow the court to affirm on other grounds that were pled, that were litigated, and that were argued. And those grounds include dependency. You could totally affirm on the ground of dependency right now without having to remand it. And that ground was pled, litigated, and argued.
I could be wrong, but I know you certainly argue emotional abuse, and we could decide it on that alternative ground. And did you present dependency in your briefing to us as well?
Oh, I did, yes. Yes, I said that all three grounds were pled, litigated, and argued. And for some reason, the juvenile court looked only at neglect. And I think, and particularly in this case, where the Court of Appeals said, we're going to send this child back to this house that arguably could be abusive, but is not neglectful. I mean, you can see how that's so dangerous. Justice Pierce?
Before the Court of Appeals, did you marshal the evidence in favor of dependency in your brief? You know, I'm sort of struggling with the concept that the court should go through and review the record to find findings that support potential alternative rulings when we do have a marshaling requirement. And so, can you tell me, was that evidence marshaled for the Court of Appeals, and the Court of Appeals just blew past it, or do you believe this court has an obligation to go through and try to search for that alternative ground?
Well, first, the marshaling burden is on the appellant. But yes, I did include evidence from the record, and dependency is the same as neglect, except for it pulls out the fault element. So to marshal the evidence for neglect is the same as marshaling the evidence for dependency, just you don't have to make a connection about fault.
So, and it was presented that way to the Court of Appeals.
Yes.
All of these findings that I've just pointed to would also support a finding of dependency.
Yes, and when you say that mother did not challenge the evidence, she made two claims to the Court of Appeals. One was a sufficiency of evidence claim, and the second one was taking the findings as they are. I think the juvenile court erred in making a determination of neglect. So if there are no other questions, I urge this court to reverse the Court of Appeals, to affirm the juvenile court's adjudication order, and as a backup, to send it back to the juvenile court to get it right. Thank you for your time.
Thank you, Ms. Pierce.
Judges, what we're asking today is that you either affirm what the juvenile court did on the basis of abuse, because abuse was certainly throughout the trial and was also in the decision. But I think more important than that, for juvenile practitioners everywhere, we're asking you to redefine emotional maltreatment so that it matches up with how it is applied in juvenile court and how psychologists view it. I'm looking at the Unseen Wounds article that I attached to my brief, and it says that emotional maltreatment represents a breach in the attachment relationship between the caregiver and the child through A, lack of emotional nurturance, attunement, and responsiveness, which is emotional neglect, they're saying, or by overt acts of verbal and emotional abuse that result in harm. So it is clear that out in the field, emotional maltreatment is emotional neglect and it is emotional abuse. And we believe we've proved both of these in our case. The other thing we're concerned about.
I'm sorry to interrupt you, but which way does the fact that mother placed a child with aunt and uncle cut? But by that I mean, you know, she's obviously has inadequacies as a parent. And perhaps recognizing that, or perhaps for more selfish reasons. But she placed them with a nurturing couple. Why should that count against her?
I think having family assist with raising a child is a great idea and should be encouraged. I think it went beyond that in this case. We're not talking about, you know, a weekend here, a week there, a summer. We're talking about years of time where family members took care of this child, where mother was basically abdicating being a mother in this case. And when she was offered additional time to spend with her child, she was not interested. So this is a mother who's just not bonded. I mean, I think that's the only type of mother who could consider selling her child. So I think that's where we've stepped beyond the bound of just trying to do something good for the child. And it looks like I'm out of time.
Thank you, Ms. Harding, Ms. Pierce, Mr. Christensen. We very much appreciate your arguments and will take this matter under advisement. Court is adjourned.
Thank you, Your Honor.
Thank you.